The answer to that question is most likely no. We haven't seen anything that's hazardous at the moment. You comply with your OH&S requirements. You have measures in place. You look at your OH&S industry guidelines and alerts, and that's when you consider whether additional pay is going to be necessary. What is hazardous pay? What's the purpose of it? Maybe you need to find someone to do that role, and maybe you have to pay them more to convince them to come, aren't prone to any health issues if they're in that position. And you should make sure you get disclosure of any medical issues during that recruitment phase. But most likely, you don't necessarily need hazardous pay. The next question we have is, I just started my business the 1st of March. I'm sorry to hear that. That's very difficult if you're just launched and you have 8 employees working on an ABN. But I have to put my business on hold. Can I claim something for my business and my employees? You don't need your business operating for 1 year, as I mentioned before. You need those employees to be on your books at the 1st of March. And as far as I can see and say, without seeing the legislation, the answer is yes. If they were on your books on the 1st of March, you're most likely going to be entitled, and they're going to be entitled to the job payer or job keeper payment. I'm trying to sift through a lot of the dialogue here, finding questions, so just one moment. So we have Gemma, and it says, employees not wanting to come to work because they don't want to take public transport to and from a place of work. How do they get to and from work? As I mentioned, you can offer cab charge, Ubers, things like that. That's an expense to your business. If it seems reasonable and there's a reason why they're not prepared to take public transport, then maybe you can consider other avenues. But the government's doing its best to clean their public transport regularly. You might want to supply gloves and masks who have to take public transport, and that might be good enough. The government's not going to continue having their public transport running if they don't feel it's safe. So keep that in mind as well. Getting into the job keeper payment, who does it apply to? Is it Australian PR only? Does it apply to backpackers and things like that? If it's a temporary visa and not a specialist visa, it does not apply to those people. 457, 482s. And it really gets to looking at the overall objective of what the policy is. The government wants to look after their people. The reason why people are on a sponsorship visa is because they're offering an essential service in Australia or a business in Australia where someone can't find another person out in Australia that can do that job. There are now a lot of vacancies and a lot of availabilities, and there's probably Australia that can fill those roles. So does that mean sending back your sponsored staff back home? Well, that's kind of what the government is kind of indicating. It's kind of saying, well, maybe you should send them back home and hire an Aussie because they will get the job keeper payment, but non-Aussie permanent residents aren't going to. Can an employer who is also paid as an employee within the business receive a job keeper payment? Absolutely. You can, but the question is have you been paying yourself as an employee, Or have you simply been paying yourself director fees and dividends? And you got to go and look at your books and see if you weren't paying yourself a salary with tax withholding, you're not going to be recorded as an employee with the ATO, and therefore you're unlikely to be able to get the job keeper, but you might be able to go in as an ABN because ABNs can get it, and you're likely to get the job seeker payment as well. So is the comparison, when you're looking at the 30% downfall, the average revenue for 12 months? No, it's not. The government is very flexible at the moment. They're saying, has COVID-19 caused volatility in your revenue? Has it caused a reduction on average? And if you can show that, and even some of the commentary I've read from the government, it even says if you predict future downturn. This law is not in place at the moment, but even a prediction of the downturn most likely will get in because the ATO is using its discretion and it's acting reasonably and it's hoping everybody simply acts in good faith. Do employees who have been employed for do they need to be employed for 12 months? No. They have to be on the books as at the 1st of March, tax withholding as at the 1st of March. Only casuals need to have been employed for 12 months and worked in the business on a regular and systematic period of time. Kate says, warning about JobKeeper for business owners where you weren't yet paying themselves a wage. As I mentioned, we got to see the legislation, but it does not sound like you'll be entitled to it if you were not withholding the tax from a wage as at the 1st of March. Mike says, what constitutes an employee? Does this cover trust distributed payment? Unlikely. Remember, this is a benefit offered by the ATO. So the question is were they employee as defined by the ATO on the 1st of March? And if you're an employee, then you would be paying a wage and you would be withholding that wage and you'd be paying super. And if you're not doing any of those, and instead you're just doing distributions or director fees, it's most likely that the JobKeeper won't be applying to you. But again, I can't be 100%, but not likely. Wendy says, I'm in telemarketing. My company started operating in early February. I'm out of business already. Am I eligible? Most likely, yes. That's going to be very difficult, is that you're going to have to prove what your turnover was in February. And then you're going to have to show that there was immediate downfall in March. If you can't prove that you had any wage or any turnover in February, then you're not going to be able to prove a downfall. And you're more likely than not going to be better off going with the job seeker payment rather than the job keeper payment. Clara says, Wendy, the slide says it does not mean the employer must have been trading for 12 months. That's correct, but it does mean that they have to be an employee. Justin says, we're film production and special FX company, and all our work's gone. And our busiest time is March to November. I'm not a business guru, but film production and FX, you got to really consider whether it's time to pivot and try to find any kind of jobs. Look at Freelancer, look at all these other places where people are putting up jobs right now. There's a lot of videography being done. So even if it's not a film being produced, you might be able to do online content. Chris says, my business of 10 years and restructured on January 1st, would casuals be considered employed from their original start. The tax commissioner has given some discretion in terms of where there's been a merger and acquisition. I can't give you a guarantee on what the circumstances that they weren't on your books. But from the sounds of it, you will be entitled, Chris. And the reason is because as at the first of, oh, sorry, you might, if you're going to have to look at the Employment Fair Work Australia Act. They have a clause called transitioning employees. A transition employee is where an employee works for one employer. That employer is then bought out by the next employer. And when they're bought out by the next employer, if they're transitioning, i.e. their entitlements have transferred across or their contracts transferred across, and they're now employed by the new company, all their entitlements are as if they were always employed. So if they were a transitioning employee as defined in the Fair Work Act, and they were on the books of the 1st of March, those casuals would likely get the JobKeeper payment, or JobKeeper payment. Business owner only open for 2 weeks, required to close, had 2 contractors. You're not going to be entitled to the JobKeeper, most likely. Gavin says, what if we have a retail shop? We had just a couple of weeks with low turnover and then closed due to safety concerns. First of all, I would be looking at your commercial lease. If you look at your commercial lease, if you had to close as a result of the shopping center closing, then you are not getting what you were promised, and you might be able to get out of your lease there. Number 2 is if you cannot have a retail shop open as a result of mandatory government incentive or government directions, then your contract is potentially frustrated by law, and therefore you may be able to get out of your commercial lease. However, if you're one of the retail shops that have made the decision to simply close because you cannot continue paying staff and maintain that shop while no one's shopping, then you probably aren't going to be able to terminate your commercial lease. There will be measures announced on Friday to deal with retail shops and commercial leases most likely. But your employees should most likely be stood down and potentially get the JobKeeper payment so that the minute everything opens up, you can bring them back right away and you still have them on the books. Derek says, businesses who have reached progression from being a sole trader to a company, is there a rollover? There is, and that's the transitioning provision in the Fair Work Act. Have a Google transitioning employees. And LawPath has a lot of articles and a lot of content and a lot of publications. And I wouldn't be surprised that they actually have an article on that topic. Claire says, must not be receiving job seeker payment, but what about if we have registered, lots of people registered for job seeker? You cannot receive job seeker and job keeper. If the employer is putting the employee on as a job payer or job keeper, then the employee must notify that they're no longer eligible from job seeker. And if they collect both, they'll certainly be doing that improperly, and they will eventually get caught for that. They're only entitled to one. Are international students who have worked part-time employee or casual employee for over 12 months entitled to this? They're not a permanent employee. They're on a temporary visa. Unlikely, and I'm pretty sure they're not going to be entitled to the JobKeeper, because the purpose is to get the Australian permanent residents and citizens and Kiwis, to keep them in their jobs and to get them into jobs. But I also know that they're making flexible arrangements, and I think they've already changed the visa restrictions regarding the 20-hour limit on student working hours, so they can now work more. So if you need that student, you'll be able to benefit from that. But I can't tell you for sure what those laws are at the moment. Kathleen says, if the employee has applied for job seeker and now it's in their best interest to be job keeper, not a problem. You can switch them. You get them this. You can switch them over. No issue with that. Does it apply to companies with only directors? If the director is receiving a wage, then yes. If they're receiving director fees, possibly not. They're not paying pay-as-you-go. They're not an employee, and it's likely that they won't be entitled to that. Are ABN holders entitled? Yes. As a director, you may not receive a normal steady wage. How does this apply then? That is a good question. If you paid yourself in March, then you're going to be an employee as at March. And it's still likely that you are an employee, even if you may not have paid yourself in March. You've got to look at whether you're defined as an employee and whether you're on the books. And the legislation will give more details, and that legislation will be enacted most likely on next Wednesday. So I can't give the finer details on that point. Where's the application form? It's on the ATO website, and I put a link in my slides for that. Does it apply to self-employed people who operate through a trust or partnership, doesn't have an employees? Likely, if you have been paying yourself as an employee. When does the ATO reimburse you? They say it's the 1st of May, but it could potentially be delayed. There would be a lot of payments. It's obviously going to depend on how many people apply for this. Chris says, what happens if an employee is on $3,000 per fortnight but stood down without pay? Then you will still have an obligation to pay the $1,500, and you'll receive the $1,500 back, but you'll also make sure that you've stood them down properly in accordance with the applicable law, and there's an agreement on that. And these slides are available, and they will be able to be streamed, fast-forwarded as well. So Chris says, does that mean you only need to pay them $1,500 per fortnight because they're stood down? Well, you're supposed to be paying them their normal wage, and they're subsidizing that wage by giving you $1,500 towards that wage. However, the issue is if you have stood them down, did you do it appropriately, or did you breach employment laws dealing with that? I'm going to get over the issues a little bit about the job keeper, because there's still a lot of employment law issues. So I'll skip over the job keeper questions because we've answered lots of those. The ATO cash flow assistance is eligible for people who have lodged a previous BAS statement before March 2020. It's a different benefit, and it's very good, and it's kind of free. $50,000. It's a very good subsidy. It's probably even, well, it's not better than the job keeper, but combining those two together, it's a massive subsidy. It helps employees a lot. So it's not just the job keeper. You can't just look at who I mentioned before, Joe, who makes $3,000. You pay him $3,000, less tax, and then you get the $1,500 back. You get all that tax that you withheld back. So you're not going to be out of pocket the $1,500. So you pay Joe $3,000 before tax. You withhold a portion of that tax. You then get paid back the $1,500 before tax. So you're out of pocket the $1,500. being the difference between the 3,000 and 1,500, you're out of pocket for the 1,500 pursuant to the job keeper, but then the tax that you withheld on the additional 1,500 you're going to get back, and therefore you're actually not out of pocket the whole 1,500, because the two combined will give you a more incentive to keep your employee on. One of my casual employees who previously earned $400 a fortnight is saying that according to the latest Treasury facts sheet, it's an underpayment and so on. To get the job keeper, you need to pay the $1,500. So you need to pay the $1,500 to get the $1,500. So if someone only makes $500 a fortnight, you got to top them up the extra $1,000. You don't have to pay super on that amount, but then you'll get the 100% rebate, basically. The 4 weeks, so I was talking about if you're going to force someone to take annual leave, and in a lot of the statutory requirements specified in the modern awards, it says that if you're going to force an employee to take annual leave, you must give them 4 weeks notice. The difficulty is that's the stated law. So if you're not going to give that notice, then I can't tell you to breach that. If they're not on an award, then it's section 94.5, which says reasonable, and it doesn't have that notice requirement. Is there a flexible working conditions policy on LawPath? There is a home policy available. Can you reduce an employee's hours? Going back to looking at whether it's standing down, making them take annual leave, putting them on unpaid leave, or making them redundant. If you were to stand them down, it's got to be mutual agreement. There can't be any pressure of you forcing them to accept that. And if they don't agree to it, then you're constructive dismissing them, and you open yourself up to an unfair dismissal, and you may have to make that position redundant and then redeploy them in a new role that's not that fixed hours and maybe at a lesser salary. I have 4 employees and all of them are skilled regional visas. Would they be eligible? I don't have the answer for that. They might be a specialist visa. I can't confirm that. If you stand down an employee, don't we still have to pay them the job keeper subsidy? If you stand down an employee, the purpose of the job keeper is not to stand them down without pay. The purpose is to stand them down with pay by getting them the job keeper. So you're correct. You shouldn't be standing anyone down and just not paying them anything. If you stood them down and not paying them anything, you should be at least paying them the $1,500. You're supposed to be paying them their entire wage, and you get a subsidy of $1,500, unless there has been a change to their contractual obligations of paying them less, which is by mutual agreement or redundancy. You got to be very careful to just simply stand everybody down. You can't just stand everybody down without a legitimate purpose, without acting reasonably, and you're potentially unilaterally changing your employment obligations to pay that staff what their legal entitlements are. And you're unilaterally changing the contract terms, and you should be very careful of that. Can you just simply agree to pay them the $1,500 per fortnight instead of the usual pay? Well, if you've reached an agreement, if you've changed their hours of operation, then potentially, if you made them redundant and re-engage them in a new role, potentially. I'm going to try to move on from the job keeper questions. So is there any relief for employees who are required to pay to stay at home, even though technically they are an employee of the company, just not currently working and on maternity leave? I don't think you're entitled to more than one benefit. So if you're on maternity leave, you're going to be on maternity leave, and you're not going to be employed currently, and therefore it's likely that you're only going to get your maternity leave because they haven't withheld any tax on their last BAS or on the 1st of March. You weren't deemed being employed at the time, even though you're an employee. You were on maternity leave, receiving the maternity leave benefits. I've already answered that question. Let's talk about cash flow. What about if I've paid wages this quarter, but I don't have any previous BAS lodgements because I launched my business in February? That's getting very much into the very specifics of your current circumstance, and I can't tell you the answer to that, and we'll have to wait to see what the legislation is. It's likely you're going to want to talk to an accountant because they're across this. What about rates? Is there any abatement if you're not able to access your building? Yes, so that's what I talked about, is that if you're not able to access your building because of a government law or shutdown, or the landlord has shut you out, there's going to be very good grounds that one, you should be entitled to an abatement, temporary relief, or two, your contract's been terminated if you actually want to get out of the lease. But it's likely that it's rent abatement. You should contact your landlord immediately and say that I'm not getting what I was promised. I don't get quiet enjoyment to the land. I am not getting my amenities, and that's because of the law. And therefore, either the contract's been frustrated or there's going to be force majeure provisions, and you can probably reach an agreement on a rent abatement, so a reduction of rent, or if you really want, terminate your lease. But it's likely that you're not going to want to terminate your lease because you're going to be wanting to go back into the company right away and start off running your business just like you were. So I'd wait till Friday and see what the government says about commercial leases, but it's likely going to be some kind of measures where the landlord's got to pass on their benefits to you as a tenant. If we use the slowdown to catch up on invoicing, and this quarter looks better than last year, but we have also had a drop in work, what other ways are available to show the loss of work? Again, they're very flexible. They're looking at volatility. They're looking at a reduction. Even if your turnover this month looks really good, there is still likely a way to benefit to say that next month you're going to have a 30% reduction. But we're going to have to look at the legislation. We're going to have to talk to an accountant, most likely, to see if you qualify. How do you prove hardship? Evidence. The evidence is going to be your landlord might want proof that you've had a downturn. You might have to show them your management accounts, pull out your bank statements. You might have to share information that you don't want to share with your employer, or with your landlord. But if you're not going to give that information, why should your landlord give you any benefit at this time? Alana asked another question, but it goes back to directors. of companies that might not be on payroll, which I've already discussed. We had subcontractors who were meant to start in a new project in March. Does that JobKeeper apply to them? Subcontractors don't apply at all. They are not entitled to the JobKeeper at all, but they're an ABN, and so they're probably likely to apply themselves directly. I'm just sifting through a lot of questions that have already been answered, so I'm not going to get to everybody and all the questions, but a lot of them have been answered already. Here's a scenario. Real person A is a sole trader with an ABN collecting rent from one tenant. The tenant no longer has the financial capacity to pay rent. So person A has allowed the tenant to remain there rent-free since February. And I can't see the rest of that message, but it sounds like it's going to be a difficult situation. It sounds like you have varied your lease. You've allowed them to stay since February for free. They're now in a situation where you're not going to be able to evict them for non-payment because there's going to be a moratorium on evictions. That has not come into legislation yet. That comes into legislation by next Wednesday. But I'm not going to comment anything more on that specific situation. But you can definitely get legal advice on it. Justin before said he was a film producer, and I said, well, maybe look at pivoting. He says, it's not about pivoting. It's about continuing on with a project on a smaller scale. And whether they can continue, whether they can use JobKeeper to keep them on. I think the legislation that's going to come out is going to be very clear. And that is are they an employee? And were they employee on the 1st of March? So if they're not an employee on the 1st of March, they're not going to get JobKeeper, period. And if they're a casual and they weren't in that position for 12 months on a regular basis, they're not going to get it. And if they're a contractor, they don't get it, but they can make an application themselves and go through that process with the ATO on their own. If we use the slowdown to catch up on invoicing, I would say rewind this video by about 3 minutes and you'll get your question answered. It deals with very similar things about the calculation of JobKeeper and what your turnover is. And even if your turnover is greater, then is there an ability to still get the JobKeeper even though it hasn't gone down by 30%? The possibility is yes, but you have to look at your current circumstance. Now that's the end of all the questions. If anyone's still there, thank you very much for staying this long haul. It was an entire 2 hours, and I thank you for staying in this whole time. For those who have left and have decided to watch this on their own time, thank you very much for listening to the entire episode from start to finish. And if anyone has any questions, I'm available, LawPath's available. We're here to help. I guess the benefit to LawPath is that we don't charge like normal lawyers. It's fixed fee. There's special packages available for this scenario. Those special packages are holding an immediate telephone consultation within within 1 to 2 days, sorting out exactly what your scenario is, reviewing all of your employment contracts, giving specific advice to each of your employees, and creating a strategy on how this needs to move forward for your company. It's all on a fixed fee. It's all at a significantly discounted rate. So you can have a talk to Wallpath about that. You can contact my firm directly as well about that. So thank you very much for joining in. There's a lot of information. We're going to be doing these seminars fairly regularly to keep everybody up to date. I know it's hard to stay in for 2 hours, but we'll try to make them short and sweet moving forward, because we've now dealt with the employment law aspect on 2 occasions. So moving forward, it will be, as we move forward, what are the new things? And highly likely we'll be doing another seminar on job keeper payments, what the law says. What does that legislation actually say now that it's been enacted? And it's likely to be held next week. So thank you very much for everybody from all around the country. And thank you for joining in. And I'm going to sign off now. Thank you. Bye.